You two go ahead and give the presentation in any order you want to start because we are dependent upon you for this fantastic information. So you go ahead and go start it. And what I'm going to do, I'm going to mute myself so that there's no distraction on my side. Take it away.
Thank you, Chair Holmes. Thank you, members of the subcommittee. I know we have a presentation to make, so I'd ask if that could get put up on the screen and shared. We can start with that. That would be great. As the chair said, my name is Tony Salazar. I'm the Commissioner of Financial Regulation. Meredith is now our Assistant Commissioner, and she was previously in charge of our outreach office, and currently that now reports to her. And she's hired a wonderful young lady to serve as her replacement. But in that role, she had a big opportunity, a lot of opportunity to be involved with the foreclosure and our housing efforts. So she's well suited, has done this presentation for the subcommittee over a number of years. I myself am a former practicing attorney, having worked with real estate and banking and finance. So I'm also aware of the the rules that apply to foreclosures and things. Do you have the first slide? I can.
Yeah. Do you want us to pull up the slide presentation?
I can take care of it for you guys. I have it here.
Awesome. Right. Thank you.
All righty.
All right. Very good. If you could go to the next slide, please, which is the agenda slide, I think it is. Mm-hmm. Very good. Thank you. The chair asked us to provide a presentation on the foreclosure process. So we're going to do that, and we'll get into maybe a little more detail than we typically do. But I wanted to go through some of these topics that look like a little, high level. But when we get into the details, you'll understand why we talked about each of these. So the first one is about the office. Then we'll talk a little bit about our complaint investigations, some information on scams and frauds. Then we'll get into the foreclosure process overview. And at the end of the presentation, we have a flow chart that you'll be able to follow that gives you every step of the foreclosure process. And Meredith will go through and talk about some of the issues in those. Then some of the major forms in the foreclosure process are the notice of intent to foreclose and the system we use for foreclosure registration. At the end, we'll talk about some activities and focus areas where we'll talk about some proposals that we had in the foreclosure front and why we wanted to go forward with that. So if we could go to the next slide. Okay, very good. So the Office of Financial Regulation is Maryland's Consumer Financial Protection Agency. For your information, we handle basically any type of financial service that a consumer could run into, short of, which means we do not handle securities or insurance, but we license and supervise for foreclosure all the lenders, the brokers, the servicers, collection agencies, and of course, banks, credit unions, and things like that. The way the foreclosure statutes are written, our office has authority and the obligation to produce certain forms, certain form notices, to collect those notices and to provide people with different stakeholders various foreclosure proceedings. We also enforce the various Maryland laws against fraud and foreclosure scams. And then you'll hear us talk a lot about the Maryland Foreclosure Registry System, which I think the governor would really be proud about that because it is not a blue computer screen like some of the other agencies have. This is a modern registration system that has some good data, manipulation capabilities. Industry likes to use it. It works really well. And you'll hear us talk a little bit about that because while we like it, there are some perhaps underlying concerns and things that the committee might have an interest in. So with that, I'm going to turn it over to Meredith, and she can pick up on the next slide.
Great. Thank you. Yep, we can go to the next slide. So as in addition to examinations of regulated entities, our office investigates consumer complaints about the industries that we regulate. In addition to furthering our consumer protection mandate, complaints help us identify industry trends or systemic issues. So consumers can contact our office and submit a complaint if they're unable to resolve an issue with a business or individual that we regulate. So in the context of this presentation, it would be any mortgage lender, servicer, broker, collection agency, or a state chartered bank or credit union. Or if they believe that there has been some violation of Maryland law, they can also report unlicensed activity or fraud and scams involving a regulated business or industry. So complaints can be submitted through our website. They can also call or email our consumer services unit with questions. Complaints can also be mailed or faxed, which we still have a fax machine, but you know, not everybody has internet access or is comfortable using the internet. So that's another way that our office receives complaints. If a third party is completing the complaint form on behalf of a consumer, like an attorney or other representative, they need to make sure that the consumer still signs our authorization form, which is also available on our website. Sure.
So, yeah, we wanted to put this information here for you so you have it, right? You've got the links, you've got the email address, you can share that with whoever you want. And, you know, also to highlight that our office is here to serve as a resource to each one of you. Feel free to reach out to myself or Meredith if you have, you know, foreclosure questions or concerns on behalf of yourself, consumers, constituents, you know, or industry folks who might have questions about that. So, you know, don't want you to forget that we are here to help you educate and help you provide constituent service. So, Meredith?
Exactly. Right. Okay, we can go to the next slide. So last year, our presentation, we spent some time talking about two of the laws that our office enforces with respect to foreclosure fraud prevention. One of them, the Mortgage Assistance Relief Services Act, or MARS for short, and the other one is Protecting Homeowners in Foreclosure Act, occasionally called PIFA. I didn't want to go back over all of that, but I did want to highlight some of the red flags. So if you hear of any of this happening, or if your constituents call you with concerns, here are some things you want to keep an eye out for to make sure that people aren't being manipulated by scammers. So the number one is requiring upfront fees. Any sort of payment in advance of a service being provided for loan modification or loss mitigation service is actually illegal in Maryland. And then any business or company that's telling a homeowner not to make any payments to their mortgage company, not to communicate with their mortgage company, also a big red flag. Another one is if a business is an out-of-state attorney or law firm, or if there's an individual here in Maryland working with an out-of-state attorney or law firm, that would also be a red flag. And then finally, any agreement needs to be clear about the terms and conditions, and should not provide guarantees that they can't make, right? Like, nobody can guarantee that they can save somebody's home. So again, if a consumer does fall victim to a foreclosure fraud scammer or a fraudulent business, they should immediately report it to our office. In addition to initiating an investigation into that company, we will also refer the consumer to pro bono or low bono legal services because they more than likely need an attorney to represent them in court. Okay, next slide. So turning to a quick overview of the foreclosure process, and there is a more detailed diagram, that handout that Tony referenced. That will be addressed after the slide presentation. This is just a quick overview so that we can give you some background before I talk about the notices and registrations. So after the missed payment or other default, the mortgage borrower will receive a notice of intent to foreclose from the lender. Then the lender will file a foreclosure action in court if they're going to move forward with the foreclosure. And from this point on, the process is generally managed or overseen by the courts. If the borrower is eligible for mediation, they'll have the option to participate in a mediation session with their lender before the foreclosure sale. The mediation is overseen or mediated by an administrative law judge who is at the Office of Administrative Hearings. If no alternative to foreclosure is agreed upon, the foreclosure sale will happen, and the court will have to ratify the sale before a deed can be recorded with the new purchaser. Okay, next slide. So now I'm going to talk a little bit more about the 3 types of notices and registrations that our office receives during the foreclosure process. The first is the notice of intent to foreclose, or NOI. This actually occurs in what you might consider like a pre-foreclosure stage. It's essentially a warning to a homeowner or a borrower that they've defaulted and a foreclosure action may be filed. The NOI is mailed first class to mortgage borrowers and the owners of record. It contains pretty detailed information about the loan, including loan number, date of default, amount past due, the name of the secure party, the name of the loan servicer. It also has detailed information about the property subject to foreclosure, including the address, the names and mailing addresses of the owners and the borrowers. Sometimes those are different names on the deed of trust versus the deed. And it also has the phone number for the servicer and secured party, so the borrower knows who to contact for assistance. If the borrower is eligible for loss mitigation, usually if it's owner occupied, then a loss mitigation application will also be included with the NOI, and instructions for completion for completing that application will be included. We use the NOI copies that we receive for a number of things. So number one, of course, is supervision. We may look up NOIs when we're doing exams, consumer complaint investigations, or if we need to for additional information for enforcement. We also do direct outreach to homeowners and monitor, use the data from NOIs to monitor trends. We mail outreach letters and fact sheets to borrowers whose names are identified on the NOI. These materials include an explanation of what an NOI is, tips for avoiding scams, resources like the hotline for getting a referral to nonprofit legal services or housing counseling. And the letter also encourages the borrower to contact their mortgage company as soon as possible, right? Because we know that if they act quickly before the foreclosure is even filed, they're more likely to save their home and find an alternative that is affordable. The fact sheet, which I've linked here, Mortgage Late Don't Wait, we updated last year, and that has additional information about your rights as a mortgage borrower in Maryland if you have defaulted on your loan. So, if you're owner occupant, you have the right to request mediation. You have the right to receive a payment history, an accurate payment history if you request that from the servicer. They're required to communicate with you. And that's all included on that sheet. Last year, we mailed over 67,000 letters to homeowners who had received NOIs. And then finally, we also have started posting total numbers of NOIs received by our office as aggregated by Maryland County, zip code, and most recently census tract, which we're very excited about. That was something that was requested by local governments and some advocates to have the census tract level numbers. So we're happy about that. Okay, next slide. Okay, so now we have a couple of graphs. This graph shows the total number of NOIs submitted to our office on a, by month, the monthly totals between January of 2020 and January of 2024, so just last month. You'll note that there were no NOIs submitted to us between May of 2020 and June 2021. That's when an executive order was in place, shutting down the submission portal that our office maintains for the NOIs, which prevented NOIs from even being submitted to our office. And because NOIs are a required step before a foreclosure can be filed, this essentially paused all foreclosure starts in Maryland during this part of the pandemic. We have additional historical data, like I mentioned, on the open data portal that goes back farther than January of 2020. And later on in one of the slide presentations, there's an additional link to our website with that information. Next slide. And then for some long-term context, this graph shows the number of NOIs submitted to us annually from 2012 through 2023. So the NOI requirement was put into place in 2008, and in late 2011 is when the requirement was refined to require it to be submitted electronically. So that's why our data goes back to 2012, right? So the highest year was 2012. I don't know if you guys remember what was happening back then, but that was really the peak of the fallout from the 2008 recession. The lowest number of NOIs was 2022, where there was just over 55,600. Before we move on, did you want to say anything about the NOI data?
No, you know what, at this point,
We'll save it for later.
yeah, we'll save it. I mean, we're happy to, be able to provide the data. It provides a good historical summary. Don't forget notices of intent to foreclose, and you're going to see this as we go forward, don't necessarily have a end in a foreclosure, right?
Mm-hmm.
So just because these are sent out, that doesn't mean that there was 157,000 foreclosures in 2012. Or that, the end of the process is going to happen. This is just the borrower or the lender notifying the borrower that the lender has the right to take an action. Some lenders don't use this tool, right? Other lenders may want to use it as a pressure tool to encourage the borrower to get engaged and whatever. So there is a bit of, different rationales as to why numbers would be different between different lenders. Mm-hmm. And I see we have a question, so.
Yes, indeed. I was going to say, let's take a pause here to ask a couple of questions on the previous slides. And we're going to start with the first question from Delegate Healy.
Okay, thank you very much. I wanted to ask, one of the things you mentioned is that the lender must provide a phone number or some contact information so that and stay in communication with the borrower through this process. What are the penalties if they don't do that?
So it's situational. And we would need like a consumer complaint or something to investigate it and look into it. I mean, the commissioner has broad authority to penalize a company for an individual action or systemic actions.
Right. I mean, I guess that would fall under our general jurisdiction, which would be $10,000 for the first, up to $10,000 for the first violation of law, and that would probably be considered a violation of law. I mean that the form itself has the line for the telephone numbers and things. So our office produces the form of the notice, and basically the lenders fill out the information that's required. So they're usually pretty good at that, but it would be 10 to 25, I believe, is our general jurisdiction. And there, you know, it would be a per violation limit. So if we found somebody who was in serious violation, we could do a cease and desist order, and we could also assess them violations up to 25,000 per.
I guess the question that was one of, back in the day when we were dealing with all these issues after the last recession, that was one of the complaints we heard from people, was that they would get these notices that they thought they were being foreclosed, and then they never heard from them again, and they didn't know what was going on. And I guess the communication became like a really important part of the process. So, you know, to leave people stranded and not have nobody to call about it.
So that, yeah, there's no question. And to a certain extent, that is a perennial problem. You know, various steps have been taken to address that. One of which is when that notice of intent to foreclose comes in, as Meredith and the slide presentation showed, our office immediately sends out information, which is new after, you know, that those large numbers. Those were steps that were taken at Maryland. Federally, there's also, and we have our own state servicing standards and requirements that mortgage servicers need to adhere to, you know, including, and I know the CFPB monitors response time on telephone calls from consumers and things like that. So, you know, there has been, I would say, a vast improvement over the last decade in terms of consumer response, the oversight they get. You know, at the same time, there's been a consolidation in that mortgage servicing industry. So that kind of is good news, bad news, right? They have a larger volume to deal with, but technology has enhanced the ability to do that. So we're aware of that whenever we can. We look into it when we get consumer complaints, we deal with it. We do examine mortgage lenders and servicers, and issues like that are looked at. Other states also do that. So if there's ever any complaints, though, they should come here and we can look into them.
Yeah, please. You know, if you hear of any of your constituents that are trying to communicate with their mortgage company and they've you know, gone radio silent, or they keep saying they don't have documents that they should have, that's a perfect example of when a complaint should be submitted, because when they get a letter from our office, their primary regulator, they have to answer.
Okay.
And if they don't answer, then it just gets escalated up through enforcement. So we can get it out of them.
Thank you. That's great.
Thank you, Delegate Healy. Delegate Lehman?
Thank you, Mr. Chair, and thank you for this this briefing. It's very informative. So I had a question about whether there is a cost to lenders to file a notice of intent to foreclose, and if so, what is that cost, and what is the cost in Maryland, and how does that compare to other states? And the reason I ask is because a lot has been made of the fact that it is so inexpensive for landlords to file for eviction in Maryland. It's like $15 versus, you know, around the country, it averages $80 to $100. And that's kind of viewed as almost like incentivizing eviction filing. So I was just wondering what the fee is like for filing for the intent to foreclose.
Sure. So the notice of intent to foreclose there's no charge for filing the notice. That's
Get the copy.
It's an early warning system that the lender provides to the borrower that the lender may or foreclose, that some trigger has been set off and the borrower is subject to foreclosure. So what happens is that's a letter that borrowers would typically send before they foreclose, but the law now requires that it come to us and it be in a certain form. So we've established an electronic system to make this better, and you'll hear more about that system. We actually
in the next slide,
part of it, right? So there is no cost for this. There is a pretty hefty cost. I don't remember what it is for actually filing the foreclosure, which would be the next That's $300 or $400.
That's it, yeah. And a lot of that goes to the Maryland.
Yeah, maybe
Housing
that's a question I should have asked. Okay, so
Right.
no cost associated with intent. That kind of makes sense if that's just in the form of a letter. And that goes to you as well as the home owner or the borrower, I should say.
Correct. Both.
Yep.
Both. So
Okay.
we do there, I mean, you know, it's an indirect cost, but we do have the authority now to assess the industry, the cost of running the registry. So up until now, the only fees that, let's say, mortgage lending industry and mortgage brokers paid was their annual licensing fee. But now we have the ability to, you know, assess them the cost of this registry system, which you'll hear about, which is, yeah, I mean, it's an electronic data system that, you know, requires maintenance, update. You change one little piece and a lot of it has to change, and all that's IT people. So, you know, it's not a direct cost, but industry is paying the cost for maintaining and operating this system.
Okay, that's helpful. Oh,
Uh-oh, I think you froze, Delegate Lehman. Okay, so let's, I think she froze. Mr. Commissioner, Mr. and Madam Assistant Commissioner, oh, did I freeze?
No,
Nope, we see you.
we hear
Okay.
you.
If you could go to your next part of your presentation, that'd be great.
You can advance the slide. Okay, so this is where I'm going to talk about the foreclosure registration system. This is the portal that Tony was just referring to. It incorporates into one online system all the notices and registrations that are required by Maryland law to be submitted to us. So copies of the NOIs that I was just discussing, those are submitted to us through this system. But it's the notice of foreclosure and the foreclosed property registrations that are statutorily required to be submitted through the foreclosure registration system. The notice of foreclosure and the foreclosed property registration are both intended to provide Maryland jurisdictions with certain information about residential properties during and after the foreclosure process. So when a foreclosure is filed and when a foreclosure sale occurs. Local governments use this info for nuisance abatement, code enforcement, law enforcement, emergency services, public policy analysis. I mean, anything that really falls under the purview of county and municipal government. State agencies are also permitted access to the foreclosure registration system. So the notice of foreclosure, or NOF, is submitted by the we're still here. Yeah, it's submitted by the party authorized to make the sale. And that has to come to us within 7 days after they file the foreclosure in court. So they mail that letter to the homeowner. There is no workout achieved. The lender proceeds to foreclosure. They have to file it in court. That's the order to docket. That's where they pay the fee that we think is about $400. And then within 7 days of filing that, they have to come to the foreclosure registration system and submit an NOF. The NOF reporting requirement was actually just went into effect in became effective in October of 2018. And it has information about the property and contact information for the seller and often the foreclosure attorney or the property management company if there is one. The foreclosed property registration is at the end. So the NOF is at the beginning and the foreclosed property registration occurs at the end. The entity that purchases the property at the foreclosure sale is required to submit an initial registration within 30 days after the sale. They also have to update the registration if certain things change. And then they have to come back and submit a final registration within 30 days after they record the deed that shows them as the new owner. This requirement is actually a little bit older. It went into effect in October of 2012. And again, this was back when there was a lot of what we call like zombie foreclosures, right? Where there's just these empty properties and nobody was living in it. There are tons of issues with the property, and local code enforcement, local housing departments were having a really tough time. So the legislature sought to create this registration. There is a fee associated with registering a property. So there's none with the NOF, but for the FPR, the foreclosure sale purchaser, which may or may not be the secured party, right? That may or may not be like the bank or lender. Often, you know, sometimes mom and pop investors buy foreclosed properties, or anyone really. But it's $50 if you submit your registration on time. If you submit it after the 30 days, it goes up to $100, and the fee is only for the initial registration. There's a fact sheet that we've linked to in this slide presentation that we've created specifically for local government officials. It has more information about how to access the registry, how to create an account. Individuals at state and local government can create an account. Our office approves it, and then they're able to access all the NOFs and FPRs in their county. So that fact sheet can be a useful resource for local government. Next slide. So this is where we start comparing the NOIs and the NOFs. This graph compares the same monthly totals in the graph that you saw a couple of slides ago with the blue bars and the NOIs with the monthly totals for the NOFs. So the NOIs are their pre-foreclosure stage, and the NOFs are submitted to us after or around the same time the foreclosure is filed. So you see what Tony mentioned before, you see this big difference where there's, you know, thousands of NOIs that may be mailed a month, but much fewer or much less NOFs are filed.
Lead to actual actions in court.
Correct. Yep. So next slide. And then we take, so this is a different perspective. The previous graph went up to 7,000. I just want to point that out. This one goes up to 1,400. So now we're looking at the NOFs, which is the foreclosure filing, the start, yep, and the foreclosed property registration. So this is the difference between how many foreclosures are filed in court and then how many actually end in a foreclosure sale. Again, much less.
Right. Okay.
All right, next slide. Okay, so I'm just gonna briefly recap some of the activities we did last year around foreclosure issues, and then I'll turn it over to the commissioner to close this out. So first, we revised regulations that govern certain foreclosure notices and procedures. We talked about this at last year's presentation. Those amended regulations did go into effect in March of 2023. We also collaborated with the Maryland Department of Housing and Community Development. They were administering the Homeowner Assistance Fund. That was money that was provided to all the states from the Treasury to help keep people in their homes who have fallen behind as a result of the COVID-19 pandemic. So we helped with servicer training and outreach because we licensed the mortgage servicers. We had a direct connection to them. We issued guidance. We collaborated with the housing department and put on webinars and info Q&A sessions where the servicers or their foreclosure attorneys could ask questions of DHCD about the process and get clarification. And as I think I mentioned earlier, we included information about HAF in our NOI outreach letters. So while the HAF program was in effect, we had specific information in the NOI letters telling people that the program was there and how to apply. We also prioritized HAF-related consumer complaints, and as I mentioned, the homeowner outreach. And we upped our game with foreclosure data. We started posting not just NOI totals, but also NOF and FPR totals on the Maryland Open Data Portal. If you go to our website, there's a foreclosure data tracker page, which is linked here. That data tracker page has the statewide data But if there's links on that page, that'll take you directly to the open data portal that has more historical information so that groups can do their own analysis of
Right.
foreclosure data.
You can produce those charts and any type of variety with that data that we did.
Okay, I'll turn it over to
Okay,
you.
great. Thanks, Meredith. So let me talk just real quickly about focus areas of 2024. I'll start with the middle one. We hope to continue refining our data analysis and posting as much as we can online. How long has Brendan been with us now? 2 years? About 3?
Just past 2.
Just past 2. So we hired a specific data analyst a couple of years ago to help our office, and he's been wonderful with giving us the ability to get this type of information and put it out. And we have other areas of the office, of course, that he works for, but you can see, how important it is that we do that here. And we're going to continue to use his capabilities and try to reach out to other data sources that we can. Now, we're also going to continue the outreach, of course, to at-risk homeowners. That's an area of focus the governor would like us to continue with. Now, I'll touch on one area. The chair may be aware, I'm not sure how many others in the committee. We were going to propose a bill to deal with some foreclosure issues. The concept was really to improve areas of the foreclosure process that we thought could be done. Because last year we had meetings with industry, we had meetings with consumers where we changed some of our disclosures and things, but we said, how can we work on foreclosure and how can we get to the areas? So, the result of that was a proposed bill that we ended up having to pull back because of a lot of flack from a lot of different sources. It must have been the best foreclosure bill, because I'll tell you what, everybody found something wrong with it, right? So that tells me, hey, we did a great job on that. But you'll see after this, Meredith will give you this crazy flow chart that is the Maryland foreclosure process. And I see Chair Holmes, talking about that. And he knows what I'm talking about. But in all those different areas, there are points that can be improved, right? No process is perfect. And we thought we had some areas to improve. So let me just tell you a couple of those that we thought might make it better and that we're going to have to go back with. One of the big areas of concern was something that is really not happening in Maryland, but we're worried it'll come here, which is a situation that has been dubbed a zombie mortgage. And this is a situation where a mortgage is on the books. Generally speaking, what happens is the original lender writes the loan off. They say, we're not going to collect, and they send the borrower a notice that says, we've written your loan off. And then they let the loan sit, let the borrower do what he wants. There's still a mortgage on the property, right? So that hasn't gone away, because never forget that, when you borrow against your house, you have 2 transactions. You have the debt, and then you have the mortgage. And they are separate and can follow separate paths, as the zombie situation reveals, because what happens then is the original lender sells the loan. After however long they want, somebody else buys it, they sit on it, and then 3, 4, 5, 6 years later, this new person who's bought the debt for, pennies on the dollar has a mortgage on the property that is unpaid, and they, out of the blue, send a letter to the borrower saying, you owe us all this money. And of course, the borrower knows nothing about that process. So we proposed a bill to address that issue, which, to be fair, is not something we see really happening in Maryland. It's starting to crop up in other jurisdictions, and it may be anecdotal in the state, but we wanted to get ahead of that. So that was issue number 1. Issue number 2 was just making some process changes. You'll hear that, there's 2 different dates for filing of the foreclosure at the beginning. There's questions about which foreclosure mediation process to follow. So we wanted to address some of those. And then one of the issues that we wanted to address as well was, we talked at the beginning about scams. It's not just a mortgage related issue, right? Everybody gets caught on these things for all sorts of different things. But the more data that is out there, the more likely it is that people could be subject to scams. And as you saw, that notice of intent to foreclose has a lot of personal data about the borrower, about the debt, about the property, and also about the lender themselves. So that information is filed through the foreclosure property registry, but because it came before that registry was created, it does not get the protection from disclosure that the data of the notice of filing and the foreclosure property registry got. So what we wanted to do was add that protection that the other pieces of data get. That would be done by basically removing it from the Maryland Public Information Act request, standards. So that generated controversy as well. The intent there again was to protect customer information, because our concern is, while MPIA allows us to protect personal information, it's got a looser standard. And we actually have received requests for information from that data field that could allow somebody who's sophisticated enough to put it all together and identify borrowers. And we wanted to avoid that. So that leads me to the last point. This year, we'll take a step back. We'll talk with advocates and stakeholders and industry reps, and of course, you all representatives, and see if we can't move forward on addressing some of those points, either through regulation or perhaps another run at a bill. So Marilyn, Meredith, do you want to present the chart? The last thing is the wonderful chart.
Yes.
Here we go.
Well, so this is my contact information. Please feel free to reach out to me with any questions. If I don't have the answer, I'm willing to bet I know who does. And then that is the general email for our consumer services unit. Please feel free to share that with your constituents should they have questions or need to file a complaint. So while we're getting the flow chart pulled up, which if possible, is there a way to pull that up and share that on the screen? That
Absolutely. I'll pull it up
awesome.
now.
Perfect.
Thank you.
One moment.
Got us covered here.
Yes. So I remember many years ago, one of the first times Delegate Holmes asked me to come in and talk about the foreclosure process, and I show up not the first year, I think like the second or third year with this chart. It was like, okay, this is I see why this can be a confusing process for not just the homeowners, but also industry as well, because each state has a different process for following foreclosure. So the flow chart was originally created in 2015. We've reviewed it and revised it, make sure it was up to date before we shared it with you all today. And there's a couple of pages of notes that hopefully will make things clear. I'm not going to go through every single bit of the flow chart. Of course, if there's any questions after tonight, please feel free to reach out to me. But there are a few things that I wanted to kind of draw your attention to. I think the main thing is that there's just a lot of decision points throughout the process. And in many ways, that's a good thing, right? It gives homeowners an opportunity to save their home, and lenders are forced to review certain documents or file certain things before they move forward. But some of these various processes were added over the years. And you'll also see that there are like 4 green squares. Oh, thank you so much. Even though those 4 squares sort of indicate that the foreclosure process will stop or won't go forward, or the court may dismiss the case. I mean, in reality, the homeowner and the lender can come to an agreement at any point. It doesn't have to be like just at those points, and even up to, I believe, 1 business day before the sale. The homeowner can even reinstate the loan completely. So if they pay all past due amounts and fees.
And one of the other points we wanted to address was add a requirement if a foreclosure filing is dismissed, we wanted to get a notice from the lender as to why it was dismissed. Because you remember the charts, there was a lot of filings and only a few actually went through to the end. But we have no insight into what's causing that, right? So we wanted to add a requirement, and maybe we go through this by regulation, but it would really help us to know how that discrepancy comes about. So this chart, just by the way, you start from the top left and work your way around.
Right. You start with the big red square. I also attempted to color code the note, so anything about mediation is blue. The sale and afterwards is orange. A lot of that, once it gets to that point, the lender's not as much involved. And the gray is kind of the meat of the process. So,
Let's take questions.
yeah, okay.
Yeah.
I'm going to say this, ladies and gentlemen of the Housing and Real Property Subcommittee. If you think we're busy now, you should have been around here 2012, 13, 14, 18, because this subcommittee now is a piece of cake as opposed to what it was back then. And I love this chart. I really love this chart. Thank you, Assistant Commissioner Meredith, because this is one of my favorite pieces of art that I've ever seen. A question from Delegate Healy.
Thank you, Mr. Chairman, and thank you so much. I would like a copy of this revised chart because I have the older one hanging in my office.
Good for you.
I'm glad it's been useful.
And my question really is about, because what I've heard has happened, and I don't know if we've addressed it enough, is that consumers, people who get caught in this situation and they get the notice that they're going to be foreclosed and it goes to court, but they're not aware that there are all these points along the way where it can be stopped, it can be renegotiated. They may not know anything. They may think, oh, I've lost my house, I have to move. And that's how you get these zombie situations where people leave and they don't even know that they think that the house is gone and they don't owe any more money on it because they took their house away from them. And my question is about how are we doing with communicating to people who get in this kind of financial problem to let them know that this process has been stopped or slowed, or you have another opportunity to talk to the lender or find another source of money to pay off your loan or whatever.
Right. So one of the key ways that at least our office does it is through that outreach letter, which happens even before the foreclosure is filed. That's because it's resource rich, and it has a hotline for referrals to nonprofit housing counseling and legal service agencies, which is really where we want to direct people. And it encourages them to call their mortgage company. I think there's some, it's always a challenge when somebody is falling behind, not just on their mortgage, but on their other bills, to open their mail. A lot of the information that's conveyed may be difficult to understand. I think the process can be difficult to communicate just in the fact that there is so many different steps, tons of different documents are required. Applications, instructions for the applications. So I think you make a really valid point about how we're communicating with people and what we can do to make this process not only easier to understand, but to let them know that it presents an opportunity to save their home, right? When they get the NOI, that's not the end. In fact, nothing's even started yet.
But I think, we do that. We participate with the local community groups and advocacy groups. I know housing, DHCD, when they had that housing money from HAF, they were running ads on TV and things like that. So they did ultimately go through all that money. you know, I think in an ideal world, we would be able to make the same type of effort that was done during that half period to get the word out through all the different media, right? I mean, we try to do it through various sources. We're of course not a foreclosure prevention agency. We're a regulator. We kind of stretch our mission to make sure we get that out there. Yeah, it is a good point. I do think though we're doing a credible job, but much more could be done. No question about it.
Thank you.
Just 1, 2, 3. So about 3 or 4 things. I know it's late, but I wanted to make sure I pointed out. So first, there is such a thing as pre-file mediation. It's not required to be offered. So if the lender wants to, or if they want to offer pre-file mediation, that application, that notice would be included in the notice of intent to foreclose. And it's called, again, pre-file because it's before the foreclosure filing. Another thing I wanted to point out is sort of the dual kind of timelines up there. That question, is the mortgage federally related? So Maryland law says that foreclosure can't be filed in court until it's at least 90 plus days after the missed payment. And then a couple of years later, the federal government, I think through the CFPB, but created the regs that required the lender to wait 120 days after delinquency. And Maryland law still says 90 days. So if a mortgage is federally related, then they follow the 120-day track. If not, then it's the 90-day track. And to be clear, federally related, that definition, which if you click that link, it'll bring you to the definition of federal code, is pretty broad. I mean, it's basically any loan made by a lender that is regulated or whose deposits are insured by a federal agency. It also includes those that are sold to Fannie Mae and Freddie. So it is a big population of loans, but it isn't all of them. And because we have 120 days in one and 90 in the other, we have to maintain different NOI forms that address both of those timelines. And also there has to be at least 45 days between the NOI and when the foreclosure is filed in court. So that's another time frame that has to be taken into account before the foreclosure can be filed. There's also 2 loss mitigation affidavits. If a foreclosure is going to move forward, the final loss mitigation affidavit has to be sent because that's where the lender is supposed to sum up the results of their analysis and why they're moving forward. It's information for the borrower. It's filed in court. If they haven't completed their analysis when they do that order to docket, when they do the foreclosure filing, then they file a preliminary loss mitigation affidavit. And then they'll have to do the final loss mitigation affidavit later. And that sort of sets up an additional kind of dual timeline. You can sort of see how that plays out, if the FLMA is filed with the OTD, if it's mailed later. And then, so for the post-file mediation, which we usually just call mediation, if the homeowner is eligible, an application for mediation or the request for mediation form will be included with the final loss mitigation affidavit. Eligibility depends on owner occupied and whether they participated in pre-file mediation. Pre-file mediation is not as common as the post-file regular mediation. And then the mediation really occurs at like the very end. So if no agreement is reached, then the property can move to foreclosure sale relatively quickly after that. And once the sale happens, it's extremely difficult, if not impossible in some ways, to overturn it. So really where you want to be working with the homeowner is before it gets to that point, and ideally before it's even filed. So I'm actually gonna leave it there unless there are other points you wanted to make about the process. I mean, those are sort of like the key things. Of course, if there's any specific questions. happy to answer them.
I think both of you have done an excellent job. And Commissioner Salazar, I am so very, very pleased that you have given Assistant Commissioner Meredith some help, because she has been in Department of One for as long as I can remember.
Yes.
A whole department of one person. I mean, you know.
I went gray over it.
That's our pleasure. She does a great job for us and the citizens of the state of Maryland, that's for sure.
Thank you.
Yes, indeed. And seeing no other questions, all of us will be getting a copy of this presentation. And again, I want to thank you, Commissioner Salazar, and I like saying this, Assistant Commissioner Meredith, for this presentation. And that concludes the briefing for this afternoon. Ladies and gentlemen of the Housing and Real Property Subcommittee, it is now 6:16. We will go into our committee committee hearing for 3 bills. Forget the bill numbers. But anyway, you've all have been emailed those bill numbers. And so we're going to go into our hearing. Let's say it is now 6:16. Let's say 6:25. 6:25, we'll go into a Housing and Real Property Committee meeting. Thank you, Commissioner Salazar and Assistant Commissioner. Take care. Bye-bye.
Thank you.
Our pleasure,
Thank you
Chair.
all.
Thank you.
Hi, Meredith.
Hi, Dina.